Ayana, a very controversial legal issue epijanity ewo Ghana. Nipa ba kwa ayana Ghana fu ni da ne so se omo pese omo tie nenum asem eye Tsatsu Tsikata. Na for the very first time Tsatsu Tsikata has spoken on the Supreme Court's rejection of Alban Bagbin ni application no. Na mo nim se Tsatsu Tsikata de okasa wankasa sa akeke. He speaks with evidence and then facts. Now, for people who don't know, Tsatsu Tsikata was at the helm of affair when the SAL for and so Ede Omo case Ekokopie Supreme Court as Supreme Court ebo assembly sign yese enye no Supreme Court netena Parliament in some so na a High Court and netena so nintino. He is the right person to talk about something like this. I was watching TV3 program somewhere last week. And Tsatsu Tsikata ba but case we no wan sheda nka hwe amfa ho na o se yempa mre foforo na onkasa mfa ho ntinem se ndrechi eno musan so ye program na Tsatsu Tsikata e join ya okasa fa ho na yentie nsem a Tsatsu Tsikata odi tudwa. O se renowned Ghanaian lawyer and statesman Tsatsu Tsikata has reacted to the Supreme Court of Ghana's recent ruling on application by Speaker of Parliament Alban Bagbin, which challenged the court's order directing him to halt his declaration of 4 parliamentary seats as vacant. In an interview with Joy News on November 4th, 2024, Tsatsu Tsikata expressed serious concerns over the justification the court provided for dismissing the speaker's application. Yeah, sorry, I'm saying TV3, I'm saying Joy News rather. And Tsatsu Tsikata share concern. What say? Like yakaso be share concern on some na say ehano pan over court no justification a court ne ma ya wo de dismiss Alban Bagbin case no na say reasons a court ne de dismiss Alban Bagbin case no ono Tsatsu Tsikata o say ehano o say the legal luminary was particularly troubled by the court's assertion that the responsibility to address matters concerning parliamentary seat vacancies lies solely with the High Court, which he argued contradicts Article 99 of Ghana's 1992 Constitution. Tsikata noted that in previous cases where the issue of parliamentary seat vacancies had been raised, the court had ruled that such cases should indeed be referred to the High Court in line with Article 99 of the Constitution. Into your say, the Constitution is clear. Say bano speaker and a parliament na eye ekonya ho nsemo a eye High Court pe ene wo say e kasa fa ho. In fact ono Tsatsu Tsikata na kra no se nia me ma moti ase no o say Supreme Court na nkasa ma a lot of rulings a case bi e beba Supreme Court na nimbia no asemo Supreme Court ne kan say momfa nko High Court momfa nko High Court ne ba ne sen ya we Supreme Court in tempate na asem ne so ma rule eye ne wanwa say Supreme Court be BBC. Also, considering a matter regarding the PNC, and in which the PNC had a critical interest, and that was not the issue before the courts. This court was dealing with a matter which had been brought by the then majority leader in parliament in order to get the court to reverse something that the speaker had done. So those analogies were completely irrelevant, he explained. Now, I'll say, but more substantially, and I think these are some of the worrying signals. Into Tsatsu Tsikata nsemo kan. Or say these are signs of worrying signals. You can say BB a signal, worrying signal, and actually say BB be say na de na ba be say no. Ebe din kan ahyase eyiyi ne ho, ebe yeye BB na otiase abehu ne say ade we a eye say ne de na actually say ade we e ba be say no no. Nti Tsatsu Tsikata say ohwe ruling na aba Supreme Court send your more na a worrying signal pan was a Ghana phone in ano yama yenibri because yan here ya wamino ebebo. Also, when you look at the ruling that the court gave, certain obvious and critical factors were simply left out. Also, ruling na Supreme Court na factors be a year obvious, a year critical. Supreme Court if you ruling him. You quoted the passage in which the Chief Justice talked about Article 99 of the Constitution, which gives the High Court powers in respect of the invalidation of a parliamentary election or the determination of the vacancy of a seat of an elected member of parliament. He added. Tsikata elaborated that Article 99 has been interpreted by the Supreme Court in previous decisions to mean that the High Court holds exclusive jurisdiction over such matters, citing several cases, including the Central Kofi, Akpafo, Likpe, and Lolobi case. Tsatsu Tsikata and Semu Awokan. I say, Article 99, in fact, Supreme Court nankasa aye rulings bebre. Woka say, e bano, seni ye kano, e kunya, Parliament e kunya, e High Court, and etena so. I say, in the South case, Tsikata noted, Chief Justice Gertrude Tukonu herself had uttered a ruling affirming that cases related to parliamentary vacancies are under the jurisdiction of the High Court. He added that even the jurisdiction based on human rights violations, which the court cited in dismissing the Speaker's application, still falls within the High Court's jurisdiction. In 2000, Walker, I say, Chief Justice Nankasa, Mami Tukano, or Nankasa Tina case so, Emma wa Nankasa rule say, case be a baby a vacancy biano, Yanfanko High Court. A High Court never say the assembly or no ankasani ruling. Name said this is the President Akufo-Addo Mreni ama yehune say Ghana judges bebre no omo ankasa dia omo ediso no case beto mu nipa no mu refi. Judge be true book, and I've said this, Judge be true book mukai 2020 election petition no. Judge be true book na judge no troye no. Ono ankasa call against the ruling in some way ono ankasa kan woni book mu. What throw book say book no 1 + 1 = 2. And this if one semba be do nenim no. Now if you say 1 + 1 = 3. Hey, I say the Supreme Court determined the High Court had exclusive jurisdiction, and the Chief Justice at that time, a justice of the Supreme Court, was a part of that panel. In fact, when the matter went on review, she wrote the decision of the Supreme Court and very clearly laid out in elaborate language. Article 99 gives the High Court exclusive jurisdiction. So since that time, na mame no Chief Justice there, na oye judge e wo case ni so. But on no kra na true ruling na, on no ni ruling no tro na clear. Say eba no vacancy e konwa ho nsem e wo parliament there. Ya tro say e High Court. Article 99 atro. It was said the Supreme Court determined that the High Court had exclusive jurisdiction, and the Chief Justice at that time, a justice of the Supreme Court, okay, may read it. Say, Tsikata further argued that the Supreme Court should have explained its reasoning if it intended to deviate from its earlier rulings on the issue of parliamentary seat vacancies, in this particular case involving the Speaker. I say, no problem. Say, Mwankasa, Munsemo Adebia Moka. Say, oh, Adieno, a High Court, and a was a court. Nende, Mwamo Pesa Motina case, Neswa. At least, as Chief Justice, a wawatina case be so sad, no. Adia was also treat him with Ghana for. Now, so Mamia and Yesa, one treat him, one Ghana for. Now, Fade, the Muyi, Yantiasia, Yehundi Koso. Also, so, if the court constituted recently wanted to depart from those judicial precedents, Article 1293 of the Constitution makes it quite clear that they have got to give us reasons why those decisions that they have given previously are to be departed from, he concluded. To Otremwa, Ghana Mratre say, we a judge, now it's in a case so, now Uma ruling. You see, the reason why they do that, they say, Mama Wati say, judge is a ruling at the Nemra. Say, judge, Edia Samoa, it to me the Nemra into Oko court. Now, Kokan Samoa to me quote judge in the ruling. And one of the ways and for lawyers be prenaying Momudi winning cases. It was a wo Mwa kansem nende embrane trese se judge Emma ruling nebe da nembra na asem no similar esanso beto judge nenim na afi judge ne peso sesana no a de wo se judge ne ye ne se wo se wo tretre mu de ntia wo sesana no nanso wei omo antre mu de ntia omo sesa omo ano, which is a critical part of the ruling or say Chief Justice na nyade. This is what a luminary Tsatsu Tsikata is saying. Don't tell me what your comment box the moment I say.